discussion? Okay, motion's been made and seconded. All in favor?
Aye.
Opposed? Motion carries. Thank you very much. Thank you. Next is docket number FIC 2019-0271, Kristen Vesta versus Executive Director, State of Connecticut, Office of Legislative Management, NL.
Good afternoon.
Good afternoon.
Commissioners, thank you.
Would you like this matter tape recorded?
Sure. Okay, thank you.
One second.
Today is Wednesday, February 26th, 2020. Meeting discussing parties or commissions reporting consideration of chapter number 2019-0271, Executive Director, State of Connecticut, Office of Legislative Management,
Just for the record, Commissioner Shaw is participating by phone. Will the parties please identify themselves for the record, starting with you, ma'am?
Caroline Beitman from the Office of Legislative Management. Beth Waters from Legislative Management.
Thank you.
Brian Festa, counsel for the complainant.
Thank you. I just encourage everybody to speak loudly and then make sure the microphone is near you. When you Thank you. So, the Office of Legislative Management, oh no, Mr. Festa, do you wish to begin?
Yes, thank you. So, this, as I stated in my brief, and we submitted that last week, this is a matter of substantial public interest. This, I think, looking around the room, I don't have to really plead that case. I'm not a regular attendee at these meetings, but I would presume that most of them are in standing room only. So this particular case involves the exemption from the Freedom of Information Act, which provides that preliminary drafts and notes can be withheld if the public interest in withholding the documents outweighs the public interest in disclosure. And here, I think it's very, very clear, and that's found at, as you know, in section 1-210B1. Here, I think it's very, very clear that the public interest in disclosing the information outweighs the public interest in withholding it. This, and I have to talk just briefly about the legislation that is at the center of this request. So, as you are no doubt aware, House Bill 5044 recently passed out of the, actually just on Monday, passed out of the Public Health Committee of the legislature. And it was a fairly close vote. It was not solely along party lines, 14 to 11. There were 2 Democrats and the rest were Republicans that did vote to pass this out of committee. But it was very, very contentious. We had thousands of people show up, both for the public hearing, which lasted 21 and a half hours on the 19th of February, as well as on Monday. We had thousands come again to the Legislative Office building. Because this legislation, this proposed legislation, involves fundamental rights. It involves the right to an education, a public education, which is a fundamental right under Article 8 of the Connecticut Constitution. It involves equal protection of the law. It involves the free exercise of religion, which is a First Amendment right, as you know. There are just very, very substantial fundamental constitutional rights at stake here. And so given the fact that there is so much controversy over this legislation, I really think this is one of those cases where, more so than maybe most others, the light of transparency really needs to be shown upon this legislative process. One of the, actually part of our requests were for some of the documents that related to communications regarding this proposed legislation, including the vaccine working group that was created by Representative Jonathan Steinberg, who's the chair of the Public Health Committee. And if you actually see in page 5 of the memorandum that I filed, it states there was actually a representative who was a member of that vaccine working group, State Representative Vincent Candelora, who stated we had drafts in the working group, but that language was thrown out. We were later told there was all new language. I think it really points to a major problem. It's very disconcerting that these elected officials are turning our open government process into a secret one. That's why the public doesn't trust us. And that was a direct quote from him from February 7th in the Connecticut Mirror. So if a legislator himself is saying the public doesn't trust us, we saw drafts, now they're gone, I don't even know where they are, I'm being left out of the legislative process, I think that really begs for this information to be released. The legislators, and I didn't bring him here today, I did have discussions, but because you said there was no new evidence that could be offered at these hearings, so respecting that, I did not bring him. But if you did make some sort of motion for additional evidence, I could bring statements and affidavits from legislators who would say that they do want this information revealed, even being legislators themselves. So I know the respondent in this case feels that it would be harmful, that it would somehow have a chilling effect on the legislative process. That's the crux of their argument. And I understand what they're saying. In many cases, I think that would be an appropriate argument because they should be free to exchange ideas without fear of any kind of reprisal or public intrusion necessarily in those preliminary stages. However, this particular legislation, the other thing that's a lot of people are concerned about is corruption. In other states, this has been passed, and this has been a concerted effort across the country. There has been evidence of corruption that's been uncovered. So in California, Senator Richard Pan, when SB 277 was passed in 2015, said that he was going to use this removal of the religious exemption as a way to expand medical exemptions. Okay, and just last year, they passed a bill that greatly restricted medical exemptions. Senator Pan actually led the effort to greatly restrict medical exemptions to the point where it's nearly impossible to get a medical exemption in the state of California, even if your child has suffered life-threatening consequences, seizures, anaphylactic shock, very, very serious reactions. They cannot get a medical exemption in the state of California now. So what has been revealed is that he was lying, is that the backroom conversations, the preliminary notes and drafts, he was having conversations with people and saying that we need to restrict medical exemptions, but yet telling the public that we're not going to restrict medical exemptions. So because there's been evidence, there was corruption in New York, passed on June 13th last year as well. But again, if you so desire, I could certainly provide you with evidence, but like I said, I didn't come here with it because you asked that I not bring it. But there has been evidence in other states of this kind of corruption. So parents are legitimately concerned. Parents are, very, very concerned that there's something untoward going on here behind the curtain, and they want to see what that is. If there are no sinister motives, you've seen it in camera, I presume. If there are no sinister motives in those preliminary drafts and notes, if there's nothing that would shock anyone here, then why not release it? If there is, then it definitely needs to be released. That's exactly the kind of thing that's the reason this commission exists, okay? This commission exists, was formed after the Watergate scandal originally, okay, in the 1970s, because there were things going on in the darkness, behind the curtain of government, that needed to be exposed, that begged to be exposed. So I just plead with you, commissioners, to recognize that there are fundamental rights that involve children, that involve parents, and that you would listen to these arguments. That's all I have.
So, obviously, the Office of Legislative Management works closely with the caucuses at the legislature, and they have to provide for the legislature to be able to be uninhibited when they have discussions with each other that are outside, the public context. We provided items for in-camera observation. That was done. It was found that those items, were not disclosable, and at that point, that's where we would hope that this would stay.
I guess I would just add that as one of my primary responsibilities is coordinating FOI requests as they come in. And regardless of the bill that they're referring to, they're handled the same way. We get the required information, the requested information, it's reviewed by people throughout the organization before it's then given over to requesters. And there's no difference in the way this particular request was handled over any other of the various requests that we get.
Excuse me, may I say one more thing? I did want to address that, I meant to, but it slipped my mind. There was the issue of promptness. That was another issue that was raised in this complaint, was that the documents were not promptly disclosed. I mean, I understand that the Office of Legislative Management gets a lot of requests, and I understand the first request yielded over 10,000 results. We were very understanding with that. We waited months before we really started pressing Mr. Tamboro for that information. But by June, we had sufficiently narrowed it, or by the end of June anyway, early July, we had sufficiently narrowed it that there were 122 emails that were the subject of this inquiry. And we had to have 3 hearings to get those any of those 122 emails disclosed. And at one point, hearing officer Attorney Harmon made a comment in one of the October hearings, at October 11th actually, that she was visibly frustrated. She said, 122 emails, I could review that over a cup of coffee, which was kind of a humorous remark, but it really showcased the fact that there was an undue delay here, and there was no reason for them to be delaying other than what I believe, and again, it's just my own personal belief, is that obviously this is a very controversial legislation. If something, the people who are deciding whether this gets released and who are, sifting through this information are the House Democratic Caucus attorneys. This legislation is being promulgated by Democratic leadership, who they work for. So to me, it's very clear there are things in there they don't want the public seeing before this is passed. As a matter of fact, the pace at which this legislation has been advanced is almost unprecedented. If you were at if you saw any of the Public Health Committee meeting on Monday, they were saying, Representative Betts, for instance, said, why are we doing this so fast? 48 hours after the public was heard, you already are putting together a draft amendments and we're voting it out of committee when there were 21 and a half hours of testimony from the public, and you're rushing this within 48 hours. And Representative Steinberg has also made a comment that, we want to have this completed, we want to have this voted out of committee by the end of February and voted on the floor of the House and Senate by the end of March, and to have a final vote. So they're really in a rush to get this done. And so what concerns me about that is, these two are definitely related. There's no question that this request is related to that legislation. And even if you rule to release the information, to overturn the decision, of course, there's a 45-day period for appeal, which then gives an even longer delay in getting this information. I beg of you, if there's anything you can do to expedite it, I mean, I know the appeal period is the appeal period, but if there's anything that you have the power to do to expedite it and get some of this information released, people's lives are going to be ruined if this legislation passes. And if we don't have some of the information, I strongly suspect that's in these 44 pages of redacted documents could change the course of this legislation. If some of these legislators who are currently maybe leaning towards voting in favor of this bill see what's in there and what the motives were behind it, my guess is they're going to change their vote. So if it's that weighty of an issue and it's that time sensitive, the session ends May 6th. We really don't have time to be getting embroiled in a court battle, or as the last person who came up here for the last case, 2 years to wait, because once the legislation is passed, it's going to be very hard to repeal it, even if there's some sort of evidence that there were ulterior motives. It's going to be almost impossible to put the genie back in the bottle.
Discussion?
Mr. Chairman, I obviously sympathetic to what's going on in the legislature, but based on what the statutes of the FOI Act is, and the findings in this case are that the respondents provided all non-exempt records to the complainant. So I know there's a lot of talk about things that are going on in the present, but, as of when this request was made, and since then, it looks like the respondents have done what they needed to do, based on our area of jurisdiction, which is the FOIA Act.
Further discussion? Attorney Harmon?
Did you want to hear from me?
Yes, please.
So, for the record, Alicia Harmon, counsel to the commission. So I did review the records in camera, and they are draft documents. I mean, the testimony was that they were draft documents. They are draft documents. And the testimony from the respondents at the hearing, which I captured in the report, in paragraphs 33 and 34, with regard to disclosing the draft documents, draft meeting notices, draft press statements, and draft legislation. So here's the balancing test testimony that 1-210B1 requires. The person trying to avoid disclosure needs to put forth the evidence of why the public interest in withholding the documents clearly outweighs the public interest in disclosure. And the legislature did that. At that point, the only question for the hearing officer is whether the testimony that was put forward is frivolous or patently unfounded. So here we are. Our Supreme Court has said, because in a previous case, we questioned the testimony put forward as to why the interest in withholding outweighed the interest in disclosure. And we said, well, we believe you testified credibly in that previous case, which is Van Nordstrom versus Freedom of Information Commission. We still think you failed to prove that balancing test, and we're ordering disclosure. And what the court said about us judging that balancing test testimony is that the commission misperceived what is required in order to qualify for the exemption. Once the public agency puts forth legitimate testimony as to why the records should not be disclosed, the only question for me and for this commission is whether the testimony is frivolous or patently unfounded. I cannot make that determination in this case. The testimony was that we want to speak with one voice, we don't want confusion, we don't want frustration, and we want to allow the legislature to candidly share their ideas and express their positions while they're considering this very important legislation. If I were to overrule that balancing testimony and order the records disclosed, the legislature would appeal and we would lose, because the Supreme Court has said what our role is once that testimony is elicited. So I have the case law, and I believe that they genuinely believed the evidence they put forward in order to satisfy the balancing test found in Connecticut General Statute 1-210B1. With regard to the promptness consideration, you can see by reading the report, there were many requests in this case, and they were large requests, which is fine. What happened was, as we went through it, and they became narrowed, like, for example, they were narrowed, the first four, there were 4 requests originally, and then in paragraph 14, we start to see that there's some narrowing of a couple of the requests, and then in paragraph 16, there was another narrowing. But some of the narrowing, as I indicate in paragraph 16, while it was identified as a narrow request, there wasn't a date range on that request. So, in fact, paragraph 16 asked for all electronic, text message, emails, social media postings, voicemail, or other materials sent or received by this whole group of people on the bottom of page 7, without regard to when those communications were created, sent, or received. That's a huge request. So I did become, frustrated when I realized that that it had been significantly narrowed. I believed that at that point I issued the in-camera order and said, just give me the records, I will look at them. And when I did that, I think that everybody in the respondent side really started to figure out there was some miscommunication about what was operative and what wasn't. And to be honest with you, as I went through the requests, it was challenging to follow the course of the request through. But once I issued the in-camera order, I think within 5 business days, the records were delivered to me in camera. The ones they were claiming were drafts, and the ones that they weren't were all disclosed. I don't believe there was a charge. So under the circumstances of this case, I thought that, was it credible that the respondents became confused about what was operative and when it was operative? I think it's fair to say this was a pretty complicated series of requests. The only suggested amendment that I would have would be to paragraph 6A, and this is all only for purposes of jurisdiction. I want it to be clear, I don't know where the legs on this decision are gonna take it, so I just want it to be clear that, in paragraph 6A, if we could just add in front of where it starts, I am requesting this clause, in addition to my 2 prior FOI requests, comma, I am requesting, because I want it to be clear to anyone who reads this that by the time the complainant filed the complaint, we had jurisdiction over all of the requests that preceded that filing. So I think that there was a lot of communication. I didn't put all of the communications between the complainant and the respondents in the report, but we certainly did have jurisdiction over all of the requests up to the second request.
Someone want to report the amendment to add that
Thank you.
language in paragraph 6A.
Second.
Motion's made and seconded. Is there discussion on the amendment?
No, sir.
Hearing none, all in favor?
Aye.
Opposed? Motion carries.
Can I just respond to that briefly?
To the amendment?
No, to,
Well, she's here to answer questions.
Okay.
I'm sure that he'll give you additional time.
okay, thank you.
Are there any questions for Attorney Hartman, or does anyone have any discussion with regard?
Well, I think, this is obviously one of the more significant issues that the legislature has had to take up and that our state has had to take up, and it's not gonna end here. But I do feel, and I know everyone's here because they feel very strongly about it, or you wouldn't be here, that it's more of a political issue really than an FOI issue. I know you're here seeking a collateral way, I suppose, to address the issue or attack what might be the ultimate result. But I think that our jurisdiction is pretty much constrained in ways that our counsel has described. And you shouldn't be discouraged if you want to pursue this issue politically, which is really, I think, where the direction should be focused more than here. Although, as I say, this is more of a collaborative way to go about it.
Anything?
I mean, I just agree with Attorney Harmon's analysis in terms of promptness and, about the finding of fact in promptness and the finding of fact and application of the law about preliminary notes. And I would not substitute my judgment for that, of course, in that regard.
I agree. I think Attorney Harmon is the fact finder and had the opportunity to examine the witness's testimony and the witness's behavior on the stand. And she found that the testimony revealed that there were not frivolous explanations as to why the materials weren't disclosed and they were not patently unfounded. And I wouldn't substitute my judgment for the fact finder who was there with boots on the ground. So I agree with you. Any further comment?
No, it's a tough standard, and the findings of fact appear the same.
You want
Okay,
to
so
opportunity to speak?
Yes, thank you. I just wanted to respond to Attorney Hartman. I believe she has incorrectly stated the standards. The standard in the statute, I know she's citing the Supreme Court decision, but the standard in the statute 1-210B1 is that preliminary drafts of notes are exempt, provided the public agency has determined that the public interest in withholding such documents clearly outweighs the public interest in disclosure. So you have to show they have the burden of proving that the public interest in withholding it outweighs the public interest in disclosure. So for her to say that as soon as they gave their testimony, the only question remaining was whether their testimony was false. To me, that does not end the inquiry, because they did not address in their testimony why sufficiently, in my opinion, and you can go back and listen to the recordings, because obviously the hearings were recorded, sufficiently why the public interest in keeping the secret outweighed the concerns that I was raising. As a matter of fact, I want to call to your attention something that I feel was an egregious error in the hearing officer's decision, which is that she did not even address my arguments in her decision. My arguments that there was corruption, that the public interest, that there were fundamental constitutional rights at stake, are not even addressed. She addresses all of their testimony and their arguments, but does not address mine. That is a serious, ladies and gentlemen, that is a serious miscarriage of justice. And if you do not address it, you will be held accountable by the court. Because she did not do her due diligence. And if you rubber stamp it, it will be reversed. I am quite confident of that. And then she cites a Connecticut Supreme Court case today, Van Nordstrom, that was not even in her decision. If I go into court and I'm at oral argument before the appellate court, and I start citing cases that I didn't brief, what is the judge going to say? You're an attorney, you know. What is my opponent's going to say before the judge says it? Is that was not briefed, Your Honor. You cannot raise a case that was not adequately briefed. She didn't raise it. She's raising it for the first time today as an element of surprise, so that I cannot adequately defend my client's position. And I believe that's also inappropriate. And finally, she said, your comment, sir, is that, Commissioner Einhorn, is that this seems to be more of a political issue. I can understand why you would say that, but Watergate was a political issue. Watergate was a criminal issue, but also a political issue. And that's the whole reason that Freedom of Information Act was created originally at the federal level, and then eventually at the state level. But the first Freedom of Information Act at the federal level was because of Watergate. As you all know this, I'm not giving you a history lesson. You're very well versed in the history of the act, both at the federal and state levels, I'm sure. But it was a political issue. It was a substantial political issue that the public, and the point was the public has a right to see behind this door, to see behind this curtain if there's corruption in politics. To say that simply because it's a political issue, that's outside of our purview, we just deal with information, not politics. I mean, that's not exactly what you said, but, I'm paraphrasing, so I apologize. But I mean, that was kind of how I took it. So I believe there were substantial errors of law, and that the decision should be reversed, and that's all I have to say. I mean, the decision's in your hands, but.
Mr. Chairman, I move adoption of the amended hearing officer's report.
Second.
Motion's made and seconded. Is there discussion? Hearing none, all in favor?
Aye.
Opposed? Motion carries. Jay, did you say aye?
Aye.
Yeah, thank you.
Thank you very much.
Thank you. Thank you.
Thank you.
Thank you all.
What's that? Start quoting all these books.